and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the issue of fraud NRI marriages. Boy and girl get married in India, they go abroad and a foreign court annuls the marriage. There is no protection for the victims of this fraud. To discuss the issue, I have with me Kirti Singh, lawyer and legal convener of ADVA, and Indu Malhotra, senior advocate in the Supreme Court. Now for the headlines. Ensure the NRI marriages made in India are not annulled by foreign courts, recommends the Supreme Court. Despite several judgments asking the government to plug the gap in legal framework, no protection for victims of NRI marriage fraud exists. And the National Commission for Women and Law Commission recommends comprehensive regulations. It's always the woman who is at the receiving end when a non-resident Indian NRI marriage breaks up. But when the marriage breaks up, no law and no court is in a position to help the suffering Indian woman. But the Supreme Court has been abreast with the complications. One such judgment sets out a roadmap for the government in case an NRI matrimony turns sour.
There are several judgments of the Supreme Court on NRI marriages recommending how the government should legislate on the issue. But the judgment in the case of Neeraja Saraf versus Jayant Saraf stands out. The husband in this case had managed to get one-sided separation order from a US court, and this case then ended up in the Supreme Court of India.
We'll see in Haryana, in Punjab, in many states, so many girls have been just deserted by their husband and they are just alone.
The direction to the government was on the issue of how the interests of Indian women who have been deserted by a NRI can be protected. The Supreme Court has made three specific recommendations. First, the marriage between a NRI and the Indian woman in India cannot be set aside in a foreign court. Second, that government should ensure adequate alimony for the wife in the property of the husband both in India and abroad. And finally, the orders made by Indian courts can be executable in foreign courts. The last suggestion can be compiled by entering into reciprocal agreements under existing law, Section 44A of the Civil Procedure Code. Section 44A enables the government to make a foreign order executable in India.
Jurisdiction problem, I would like to say that marriage is performed in India, but all the cruelty has taken place abroad. The problem comes up when the girl is not in India, or the girl comes back in India, but all other issues like divorce, maintenance, everything is settled abroad. Now she wants her citizen to be settled in India. This creates a lot of problem because the boy is not coming back. That is the problem.
Despite this order being made over 17 years back, the Supreme Court orders are yet to be acted upon, because of which any order that are passed by Indian courts in such matters will have no implication on the NRI resident, as he is out of the jurisdiction of the Indian authorities. It is not only the Supreme Court in its various judgments but also the National Commission for Women which raises the issue of having a conclusive legislation for NRI marriage in India. So the burden goes to the Parliament to bring a suitable law for this. Aruna Thakur, Rajya Sabha TV.
Why is the government not being able to provide a framework to prevent such incidents? Ma'am, Singh, first of all, what should be done to plug this big gap? For example, the Supreme Court suggested 444A of the section that was quoted out there. Yes, CPC. Now, how can that be used, and is that a viable suggestion? Can it be done?
Well, in a sense, it's the only suggestion. Because apart from certain, apart from declaring the divorce invalid, etc., in India, in the foreign land, the divorce exists. So as long as the person doesn't come back, it's okay for him. And also, as far as enforcing other decrees are concerned of the Indian courts, you have to enter into bilateral agreements with the the other governments, particularly in areas where more Indians live, where more NRIs exist. For
Yes.
instance, UK, Canada, Australia, New Zealand, etc.
Middle East,
You
yeah,
have from
yeah.
Middle East, and you have to have bilateral agreements, which will then see that your decrees are respected in those countries.
Ma'am, without
and-
going into the actual length and breadth of the whole thing, do you think it's doable, and do you think it's doable in a time frame for the government? If there is a will on the part of the government, can it be achieved in a certain
I
time frame?
definitely think so. I think it's been a neglected area. Even we haven't even looked closely at the Hague Conventions to see which ones we should sign and which we shouldn't. And I think it's high time that we do so, because the Hague Convention on abduction of children, for instance, should be signed so that children who are abducted and taken away can be retrieved by the Indian mother, or you know, other conventions
I get
like
it,
that. And it is a neglected area. And though recently there has been a NRI cell and a ministry which is looking after it, I still think a lot requires to be done, including setting up a whole framework in which we
plug the
have
gap.
to plug all kinds of gaps initially when you get married. How do you
To
take
various
undertaking-
stages.
At
I get
various
it.
stages.
I'll bring in Ma'am Malhotra. Ma'am, the way you see it, while you are studying a case in the Supreme Court from the legal perspective, where do you find the basic problems in getting the victim the kind of help and the kind of, to ensure that she gets her rights? What are the difficulties, 1, 2, 3, 4, that you've actually come across while translating and getting it from the court?
The difficulty, I think, is more in the enforcement of the orders, because now the Supreme Court has become liberal. The Hindu Marriage Act has also been, there's been an amendment wherein now the legislature provides that wherever the wife is residing, she can, file a petition, because she automatically gets jurisdiction. The point comes in having those orders enforced in foreign countries. And sometimes, like there was a matter I was appearing in yesterday in the Supreme Court. The court in India had jurisdiction, the court in US had jurisdiction, parallel proceedings were going on in both courts. So it becomes a problem, because sometimes the foreign court doesn't stay its hands, even though proceedings are going on in India and the couple are of Hindu origin and they have been married under Hindu law, they sometimes continue to proceed with the matter. So that becomes a big problem. And for that, a device has, been evolved of anti-suit injunctions to restrain the other party from proceeding with those cases. So enforcement is a problem, and sometimes with parallel jurisdiction, both courts, once they are seized of it, keep passing ex parte orders. So it becomes a problem in these cases.
How can we plug it? Is there a way it can be plugged? And
Well,
what should the government be do to plug it?
For instance, one of the problems that I have noticed in many cases that come to us is a problem relating to custody. And what happens is that the woman comes away with the child, and the parallel court in the States keeps on passing orders against her and giving custody to the husband, with the result, and other favorable orders to the husband, with the result that the woman really cannot dare to step out of India and fight her other issues. And then, of course, the Indian court is, on the other hand, looks at the welfare of the child and so on. So I think all these issues would be solved if, if, for instance, we looked at the Hague Convention of abduction, parental abduction, we signed it. We can solve these issues in various ways. But
And they're also
and
enabling
as I
clauses.
said earlier, and as I said earlier, through bilateral agreements, through the conventions.
But this has been going on for the last 18, 20 years. Why has there been a step, or are you people aware of any step that the government has taken to plug the gap first, and the second, thereby, the existing protection that is available to these people, to the victim, is just judicial pronouncements. Apart from that, do you see any legislative activity or the government which has taken action? Because this NRI issue has initially, just about 2 decades old, or maximum 3 decades old.
Yes, no, You're right in a sense that the government hasn't taken all the steps that it can. And apart from setting up a welfare officer, say in certain embassies and consulates abroad, who's supposed to help the woman in distress, it hasn't really set up the kind of structures it can, and I'm very hopeful that it will now, because the NCW is suggesting a series of steps. For God's sakes, take all the particulars of the groom when the marriage is, happening, after which you can do a number of things, and they are suggesting steps which should be taken.
On that note, it's time for us to head into a break. When we come back, we will tell you about the recommendations of the National Commission for Women. Welcome back. Taking a cue from the Supreme Court, the National Commission for Women has been recommending that the government bring in a comprehensive regulation on the issue of NRI marriages, so that all the laws which provide protection to Indian women with regard to marriage, divorce, maintenance, inheritance, and custody of children can be made applicable to victims of fraudulent NRI marriages.
The legal complications get multiplied when a marriage steps out of the borders of a country, especially so with the NRI marriages, as these marriages now have to stand the test of private international laws. It is a difference in the approach that each country has towards marriage that creates complexities. The National Commission for Women is at the forefront of tackling this issue. According to the National Commission for Women, it is only the educated victims who manage to exercise their rights.
हमारे पास एग्जीक्यूटिव के पावर तो है नहीं, हम रिकमेंड करते हैं, तो उस रिकमेंडेशन के चलते मैं यही कहूँगी कि इनके लिए कोई ऐसा कानून बनना चाहिए कि इनके पासपोर्ट इनको दोबारा नहीं दिए जाएं, ताकि वो यहीं रहें.
The National Commission for Women has recommended compulsory registration of NRI marriages. The Commission has also asked the government to effectively represent to the foreign governments with large NRI presence to give effect to issues on overseas marriages as brought out in Hague Convention. The Commission has also suggested that the Ministry of External Affairs, through its embassies, should sensitize the home departments of foreign countries about issues relating to dowry demands and other problems faced by Indian women.
यहाँ लड़कियों को सपना दिखा के मैरिज करके वहाँ ले जाते हैं, वहाँ उनसे घर के काम कराते हैं, लेकिन जब तक इनके लिए सख्त कानून नहीं बनेगा, मैं नहीं समझती कि इन पे कोई रोक हम लगा पाएंगे.
According to the data of NRI Cell, around 225 women from metros get married to the NRIs every year, and out of this, a high number of marriages fail. The highest number of complaints were registered in Delhi. Delhi has registered 73 cases related to NRI marriages, followed by Uttar Pradesh 43 and Haryana 40 complaints. Ever since the National Commission for Women started the NRI cell, about 515 cases have been registered. Precaution is better than cure. So if any Indian family is looking for an NRI groom for their daughters, it is the foremost duty of the parents to get their daughter's marriage registered. Aruna Thakur, Rajya Sabha TV.
Okay, a small thing like seizing the passport of the offender. How difficult is it for the government to do this? Ma'am, before I come to this question, I would like to take a point from Mrs. Malhotra that the complaints that you saw, do you think that's a realistic figure, or there are not many who are coming forward to register complaints?
I don't think that's a realistic figure, because the marriages with NRIs don't take place only in the metropolitan cities. There are a large number of marriages I know which take place in rural areas, in Punjab, in Kerala, etc. So definitely 73 is not a realistic figure at all. And sometimes the victims are not in a position to defend themselves and to get access to justice. So therefore this figure would not be realistic.
Ma'am, coming to you, ma'am. On the complaints, you said 700 complaints are pending out of whatever that has been registered. What is the reason behind the pendency?
The reason, I don't know what the reason behind the pendency in the NCW is, because these are just complaints in the NCW. But what I'd like to say is that a number, talking about registration of marriage, I'd like to say that not mere registration, but there has to be also a full disclosure by the groom of his assets, of what he is earning, where he is earning, his security number in the foreign country, whether he's if he's a citizen of India, it is still easier, but if he's a citizen abroad, then all these particulars must surely be had. And it is actually some very enterprising
If you do this, ma'am, the rest of the 50% marriages which are succeeding, that will go out of the window.
No, not at all, because it's a mere formality, paper formality at the time of registration. And if the government wants you to do this in a particular place, then it will be done. Because apart, you see, unless also a kind of undertaking that if anything happens in a foreign country, there is some property which can be identified which will stand security. Somebody has to take security for this, because there is no way, I tell you, it's practically very difficult to enforce maintenance and, abroad. And because the girls are not in a position to go there, they're not even if they can go there, they can't afford the legal fees.
That's the point.
Yeah.
And they
That's the
cannot
point.
afford, and legal aid is very few and far between in places
Exactly.
like USA. So there have been several cases in which we've asked, particular states in the United States of America to suggest some legal aid society, and we've been really unable to get effective relief in most instances. So this lack of access that women have. If there was a property which was identified here in India, at least she could enforce her claim of maintenance against it. It could be attached, and therefore it is very necessary, I think.
Ma'am, I'll bring you to the point that the chairperson of NCW was making, कि इसको बिना कानून बनाए इस पे कोई रोक पाना मुश्किल है.
हाँ.
अब इसके लिए eventually it all lands up in the court of the government,
जी, जी.
legislation. So it is eventually legislation which is going to change the thing. As of now, we have got whole lot of recommendations from NCW, Law Commission, Supreme Court, and all other other recommendatory bodies. But legislation, what do we have in the name of legislation? Ma'am, first of all, you.
Well, there is a very big vacuum in the legislation, and Supreme Court has been trying to fill it up from case to case basis by bringing about various guidelines. Like in one very important decision, Supreme Court said that if an NRI marriage is annulled on a ground which is not in the Hindu Marriage Act, it's null and void. So the Supreme Court has been trying to fill up the gap. One of the major problems which I find is that girls who have got married abroad and come back, now once they move the Indian judicial system, it is so slow in providing maintenance. It takes them years and years before which that they can get any favorable order and implement it and start getting maintenance. They cannot afford to go abroad and fight because it's extremely costly, and very often people do it on a contingency basis. Therefore, they are in that unfortunate predicament that they don't get relief quickly in their own country, because in family courts it takes for years before they get some elementary amount, and they cannot afford litigation overseas, although they would get a much more handsome amount. That is the problem which is realistically there.
Ma'am, on that note, it's time for us to head into a break. When we come back, we'll show you an interview with advocate in the Supreme Court, Geeta Luthra. Welcome back. My colleague Aruna Thakur spoke to advocate Geeta Luthra and tried to understand the legal complexities.
Ma'am, how far are you in favor of making a comprehensive law for NRI marriages in India?
Sometimes to make their status, improve their status in life, knowing fully well that people are earning in much higher salaries abroad. So this temptation for a parent, particularly in an arranged marriage, to find a NRI groom is very high. There are several cases of fraud, and it's unfortunate that people go by an advertisement and just marry their children to an unknown person abroad, whose background you don't know, whose details you don't know, except that you know either their parents or some relative living in India. So in my view, there should be a law or at least codification of what should be done in the case of NRI marriages.
registration of marriage is a major evidence in NRI marriage. So what our Indian law talks about it?
See, registration of marriages in India is not compulsory, and we should forget across the board, actually registration of marriages should be made compulsory. The only issue is that we have people who are of middle income group, we have people who are very poor economic means, we have people of the high income group. For a middle income group and the high income group, registration would not pose a problem. We are talking of poor people for whom the marriage itself is a big deal. For them to be able to go and do the red tapeism in a government office, have the access to an ADM, get a registration is little difficult.
There are very liberal divorce laws in Western countries. And problem comes when one party takes an ex-parte decree. And so if this is a case, what is the remedy to the other party?
Having said that, the question is, what if somebody gets a divorce abroad? You would file a petition in India seeking a declaration that that divorce is on grounds which are not available in India. Firstly, you would say that if that country didn't have jurisdiction or that state didn't have jurisdiction, you could challenge that in India. Secondly, there is a judgment of Justice Wadhwa, one lone judgment of the Delhi High Court, which says that if the girl does not have the financial means to contest the proceeding abroad, then even that could be a ground which could be a challenge to the decree. And the most important is, of course, the merits of the matter. Because you have been married in India under the Hindu law or the Muslim law or the laws pertaining to Christians, the law pertaining in India will be the law that will govern your divorce, even if you get divorced in a foreign country.
It's a complicated issue, but I'm sure some remedies and immediate relief can be made available to the victims. What, according to you, ma'am, should be the immediate relief, and which is, for example, you were talking about impounding or taking away the passport. How quick should it come into role? When, at what phase, and so that the person who wants to travel should be stopped wherever he is? How can that be done?
Now, impounding the passport can only be done if there is a proceeding pending and summons and warrants are issued. So, under Section 10 of the Passport Act. So, that is one case in which passports can be impounded. So, because otherwise they don't submit to the jurisdiction
Ma'am,
of
that
the
can
court.
be done.
So
I'm on the point, how quick can it be?
It can be done
information of
fairly-
the court has to be translated to the passport office so that that is executed immediately. That is where the problem is.
Yes, well, that should be done as quickly as possible. That's all I can say, within a
that is
day
where
or
the problem is.
So that is one thing. The second thing is that lookout notices can be issued, by the police. The third thing, I think, is that once the person submits to jurisdiction, then immediately from the person who's residing abroad, an undertaken should be given and some guarantee should be taken that how will the maintenance be paid when it is allowed, etc., by attachment of property or by whichever way, whether his father or mother-in-law. The fourth thing is that the wife who's left behind should be given a right of residence in the in-laws' home or wherever, or an immediate place where she can reside along with the child if she has a child. Then, of course, in the embassies abroad, the registration of the marriage can be done. The embassies abroad have welfare officers who should be able to take certain steps, who should have full particulars of the groom and of the marriage, so that they can step in and also take care of start proceedings for impounding of passport, etc.
And the other activities.
And the other
Ma'am,
activities.
I'll get in one last legal perspective from you, ma'am. On the Foreign Marriages Act, what actually needs to be done on that thing to change?
Kirti wants to.
Yeah,
Okay,
Kate.
sorry.
Yes, ma'am.
One of the things that I would suggest is the Foreign Marriages Act can be amended to bring within it certain reliefs which can be given. Simple things like, you have to wait for a 3-year period before you can apply under the Foreign Marriages Act. And the Foreign Marriages Act merely applies to marriages in which one person is Indian. But sometimes they are both citizens of, say, the United States of America, both husband and wife, in which case the Foreign Marriage Act should be amended to apply to that situation. The 3-year waiting period before you can file a petition should go. And certain other consequential reliefs can be added to the Foreign Marriage Act so that it becomes far more effective, because it is supposed to deal with marriages in which there is one foreigner involved. And I think it can be expanded. The scope of the Foreign Marriage Act can be expanded. And of course, right now you can get all the reliefs that are there under the Special Marriage Act if you go under the Foreign Marriage Act. That can remain so, and yet there is certain other, for instance, as far as maintenance and all are concerned, as I was saying, certain attachment
security and that can be taken before the thing.
Yes.
At that
Within a
note,
time period.
Yes, ma'am.
Yeah,
Yes, ma'am.
my thought is a little different from Kirti's. I feel we also need to take a balanced view. We cannot be pro-women and say that, their passports should be impounded, lookout notice, because you disable the man also, because sometimes there are temperamental differences which lead to break of marriages. So you can't even victimize the man, because I have handled a lot of litigation for both sexes, men and women. And I find sometimes men also do get victimized a lot. Their compulsory registration, information of registration of marriages with embassies must be there. And of course, you can have details of both their assets, because when a wife is also asking for maintenance alimony, the courts also take into consideration whether she is competent and whether she is earning. So information of both spouses should be made available, and a balanced view has to be taken. You can't even hound a man too much that you disable him from earning.
Right, I get it.
I would take a more
broad view on that.
I would take
Ma'am,
that.
on that note.
Because
on
I
that
am
note,
appearing
ma'am,
for a lot of NRI husbands also, where the wives have, come
Created
away with the
yeah.
child, and the husband is really trying to get redress, and they also suffer a lot.
Yes.
So we can't even hound them too much that their passports are taken, they are treated like criminals, lookout notice.
No.
Thank you,
Passport can
ma'am.
only be
Ma'am,
taken
thank you,
under
ma'am, for
certain
joining us on this
circumstances,
discussion.
under
It's time for us
Section
to end the
10
show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.